have issued one communication wherein they are saying that the proposed office, which they have earlier allotted for the purpose of this backward commission, now they are saying in this communication that it will be for the camp office. So once they are opening a camp office over there, my lords, so there is no point of shifting the headquarters.
Let them decide. It is their prerogative. They want to have camp office, they want to have principal office, but they want to have any other office.
We will file the response.
Let us, the judiciary, we should remain aloof, away from the decisions, assuming those have been taken for political considerations, unless we find firmly that yes, such a decision is directly in the teeth of the constitutionality, constitutional philosophy, some part 3 or any other provision of the constitution. There we need to interfere whether it's a political decision or non-political.
My lord, they have not even filed the reply for the Honorable High Court to take into consideration those things, my lord.
Yes.
Without even availing the elementary opportunity to
And
file.
therefore, without even taking the reply, this stay has been granted.
My lord, with regard to the communications, for the reason because as per the communication, the chairman has issued a proposal. Now he is saying, and already the state is saying they are in a financial deficit, my lords. So once on one hand they are saying that we are having a financial distress, on the other hand they are shifting the offices.
There is no further explanation.
State of Himachal Pradesh is agreed by an interlocutory order dated 9th January 2026, passed by a division bench of the Himachal Pradesh High Court, whereby shifting of the office of Himachal Pradesh State Commission for Backward Classes from Shimla to Dharamsala, from Shimla in bracket Kasumti to Dharamsala has been stayed. Next paragraph. Since the issue that arises for consideration pertains to grant of ad interim stay, it is not necessary for us to state the facts in extenso. Suffice to mention that the Himachal Pradesh State Commission for Backward Classes has been constituted for identifying the caste and communities who are entitled, who would be entitled to certain benefits meant for the backward classes. The chairperson of the commission was appointed on 3rd December 2025, followed by induction of members on 23rd December 25. The state government thereafter took a policy decision to shift the office of the commission from Shimla to Dharamsala in Vipet district, Kangra, and to maintain a camp office in Shimla. Next paragraph. Learned Counsel for the Appellant State submits that such a decision was taken in public interest, keeping in view the demographic realities, as most of the backward classes, as the OBC population is largely residing in the lower hill districts, broadly known as Kangra and adjoining area. The as shifting of commission to Dharamsala will facilitate the access to the commission, will facilitate the commission to have access to the OBC communities, most of whom live in remote rural areas. Next paragraph. In our considered opinion, in our prima facie it seems to us that shifting of the headquarters of an institute is essentially a policy matter where there is least scope of justiciability. Save and except when such shifting directly affects the constitutional or civil rights of the public at large. It is difficult to formulate such an opinion at the stage when the state government has not even filed its counter affidavit. As the matter is pending before the High Court, we do not deem it appropriate to make further observations touching the merits of the case. However, there seems to be no justification at this stage to restrain the state from shifting the office of the State Commission for Backward Classes from Shimla in Kasulti to any place in Kangra district, including Dharamsala. For the reasons above stated, we allow this appeal, semicolon, set aside the intent order dated 9/1/2026. The appellant state shall be at liberty to shift the office of the commission to Dharamsala or any other suitable place, subject to final outcome of the pending proceeding. Next paragraph. The state government or the state backward class commission may file their replies to counter affidavits within a period of 4 weeks. The writ petitions may file their rejoinder if any within 2 weeks thereafter, to enable the High Court to decide the case on merits. To enable the High Court to decide the matter on merits, to finally decide the matter on merits. Next paragraph. It is clarified that the observations made herein above are for the purposes of interim stay. So the appeal stands allowed in the above terms.
Obliged.
We may be permitted to give a physical appearance in this matter. We may be permitted to give physical.
You want to file appearance? Sure.
Obliged.
Obliged.
Well, it's item 7. This controversy, my lord, can be traced back to a minor ammonia leak that happens in a French fry factory. My lord, as soon as the incident takes place, my lord, when the incident took place, my lessee was in fact in possession of the property. Thereafter, my lord, soon after, the authorities come and shut down the entire plant. I approached the High Court, my lord, for desealing of the premises.
Why didn't you go to NGT?
My lord,
Why didn't you go to NGT?
my lord, I was impleaded, my lord.
NGT proceedings were there, you got yourself impleaded. Now you open a second parallel proceeding before the High Court.
No, my lords, if I may just correct, you know, if I may just point out this alone. NGT proceedings were so motu initiated and I was only impleaded, my lord,
You
subsequently.
did yourself, so if you had any grievance with regard to the sealing or its import, you ought to have approached the NGT. Skirting the NGT, going to the High Court, isn't it
it's today-
forum shopping?
My lords, today I only want one small relief from your lordships, my lord. I only want my right before the NGT be kept alive.
No, you want to go, please.
I'll go for the NGT. My lordship may kindly clarify that they may not be influenced by the High Court's order.
You don't require any clarification. You are not here before us to seek this
Because that the
clarification.
desealing of-
We are not your
My
advisor.
limited submission, my lord, is that the desealing of the premises can be subject to the orders of the NGT. My lords, tomorrow if the NGT actually, my lord, states that the premises is all the activities are being carried on in accordance with law. Interesting.
So, and,
My lords, I have no intention of running the unit unless and until I have the blessings of the NGT.
sorry.
My lords, I don't
Okay.
want to run the unit. My lords, I only want your lordships to say that the NGT
This
may
is
not be
no ground
influenced by the High Court's order.
to prosper the High Court. Yes, Mr.
I'm obliged.
The problem will multiply when the other party comes.
My lords, tomorrow if the NGT doesn't find fault with me, I'll have to file another writ petition, my lords, and get a clarification from your lordships once again.
Maybe
Is my
we
only.
will rely upon that we have already, this is a seal of approval of this order.
I'll leave it to your lordships. I'm obliged.
Yes, madam.
These are which matter? These are left out matters.
Yes, my lord. Some matters which remained on that last date, my lords, when my lords were pleased to grant us the absolute bail where my lords have granted interim. These are ED bail in the same matter, my lord, in DMF, wherein the predicate my lords have granted us bail. My lord, the second one is a ground of arrest that we have challenged for Ranu Sahu, and third is a DA case, my lord, in which my lords were pleased on the first day to grant us interim protection because I was already in custody for around period of 2 years.
Are these matters where you came late and we had issued notice on that day?
No, these are matters that were left over, my lords, which could not be heard because
Could not be taken. So I think we'll not be able to take a different view.
Melis,
Eh?
in item 9 Melis is a writ petition. 8 Melis.
My lords, I appear for ED in 8 and 8.5, my lords. Sorry, 8 and 8.1, my lords.
So do you have that old chart which we are having on the, Madam Ashwarya, do you
My
have?
lords, in my matters, my lords, for ED, your lordships may record my objection and I leave it to my lords.
All right, yours is item
8.1, my lords.
8.1.
Yes. 8.1 is arrest, my lords. I think there may not be too serious in pressing that. That's quashing of arrest.
My lord, 8.1 is we were challenging the ground of arrest. So my lord, if bail is being granted in 8, my lord, then we will not press that.
Yes, so lordship may record that and then I
my lords, I appear.
dispose of 8 and 8.1.
Also do.
In this matter, my lords, interim bail was granted on 29th May 2025.
Where is the note?
Is going to be another.
One is also this Ranu Sahu,
So 8 and 8.1 are Ranu Sahu, my lords.
the ED matter.
Yes, 8.1, they won't press, they are,
Press के खिलाफ में है और
so Lordship may record that. An interim bail, my lords, was granted on 29th May 2025.
Lords, 8.3 is also a bail matter of a smaller player.
8.2.
come one by one.
So this 3145,
My lords, that
Ah.
is the ED DMF bail, my lord, on which my learned by the senior is saying that she is not going to press only formal objection and the interim bail of 29.5 can be made absolute. 8.1 I will not press, my lord.
anyway, 3145, we will allow
My lord.
in the sense that interim bail already granted is made absolute. Huh? So this will be same order as
Yes, my lord. Same order.
where we had earlier recorded Mr. Raju had appeared on that occasion. So same paragraph, except that instead of Mr. Raju, Madam Mashruya will appear. So 3145 is allowed to this extent,
3644 not pressed.
and which one you don't press?
My lord, 3644, my lord, it was in the
36
same matter, ground of arrest we had challenged in the High Court, my lord, say SLP against that one.
No, 3644.
Yes, my lords.
You don't
We will not press, my lord, because my lords have granted us bail, my lords.
say in view of the fact that while separate order of even date, the petitioner has been released on bail.
My lords.
Former learned counsel for the petitioner does not press this petition.
Most of
So
them.
accordingly dismissed as not pressed for.
Grateful, my lords.
So now we are left with, at serial number 8, there are two matters only.
No, my lords, there are more.
No, it's 8.2 is a writ petition filed by Ranu Sahu, Malas.
Eight
No notice has been issued, we have not been served, Malas, 8.2.
8.2 is a writ petition, my lord, because I was arrested 3 times consecutively. Whenever my lords used to give us,
We can't issue omnibus direction, it will be very difficult. Tomorrow if you come assuming, we are not saying about you, but assuming a person, he says, grant me a preemptory bail order, and he commits murder, the authority will be helpless. They will keep on watching there because the Supreme Court has said that, no, we can't arrest you. So it all depends upon, we have been rescuing you, as and when occasion arises.
my lord, I bow down to that. We only came, my lord, after 2 years, when my lord on 3/3/2025, in a matter where I was under arrest for around 1 year, 8 months, my lord granted us bail. ED on the same day moved a production, my lord, and then sought my arrest. It is only then, my lords, that because it was becoming something in perpetuity, my lord, because I was getting bail by my lords were kind enough to grant us bail. The next day or the same day, either EOW or ED was coming and arresting us, my
But it
lords.
seems from the variety of cases against you by ED, by Anti-Corruption Bureau, by this,
My lords have been extremely kind to us, my lords.
I think my
Same
colleague should
property-
choose between not pressing or dismissal.
No,
my
no, my
lords.
lords, it's writ, my lord. The same issue, same properties is being circulated in all cases, my lord. In DMA,
maybe obviously because if you have, their allegation ultimately is what?
statement.
That you being an IS officer, you misuse your position, abused your power, and earned illicit, right, benefits, maybe through gratification, maybe through shareholding, maybe whatever. These are all set of allegations subject to trial. And you have parked that money in buying some property in your name, buying property in the name of your brother or your family members. So ultimately it is the Indian currency only. They are not talking that you are converting into dollars. It's the same property, same set of allegations.
I am in my lord's hands in this, my lord. My lords may decide it as, these are issues that we have raised, my lord. One only thing, my lord, that there were DMs after me, there were DMs before me. Nobody has been investigated also, my lord.
Withdraw this petition saying that you will approach the appropriate forum as and when occasion arises.
Permit us to come back also, my lords, if they file another case.
You have been, there is no question of coming back. You have never gone out of the court. You have always been here in one or the other matter. You are always, any litigant who is aggrieved by of an action or of whose liberty has been supposed compromised, we never say our doors are closed. You are always,
I leave it to my
will
lord.
consider act per law. After arguing the case for some time, learned counsel for the petitioner does not press this petition. As according to him, he will approach the appropriate forum as and when occasion arises.
My lord.
Ordered accordingly. Now, any other item?
Eight
as
point
per the
three,
date?
my lord.
My lords, 8.4. 8.4.
8.4. 8.4.
My lords, 8.4 is a matter where anticipatory bail
Yes, approved.
of Ranu Sahu, my lords. My lords were pleased to grant her interim bail on 29/5.
That
And
in-
Guru matter.
Yes, my lords, in DA case.
So here also you make the same, these also made absolute on the same.
I'm most obliged.
My lords, 8.3 also is the same. It's a Manoj Kumar Dwivedi. He's a smaller player.
Yeah, my
He may also be granted.
8.3 is
8.3
from Manoj
lordship
Kumar
is-
Dwivedi.
Yes, my lord.
Yeah.
Manoj Kumar Dwivedi.
So that's also same.
He was granted. bail.
I'm 8.3, I don't.
8.3 is an ED matter,
ED matter.
Lordship. Mr. S.V. Raju appears. in
ED
this-
matter, you are right. ED
Yes.
matter.
In that matter, he had asked me to take a passport.
He is not better than,
I get it. The interim order is there already.
the same order, huh? All right. ये ईडी का मैटर होगा, इसमें मैडम ऐश्वर्या का इनका साथ में he is appearing independently. Raju
Yes, yes, Mr.
Raju
Raju.
along with this
Yes.
young man. 8.5 is also
Well,
there.
if 8.5,
Vedram,
he was not arrested during investigation. He's an excise officer. And my lords have granted bail.
Excise officers order.
My lords, while order dated 29/8/2025. He was not arrested during investigation and was granted bail by this court, interim bail. Yes, my lords, interim bail.
release now.
Yes, yes.
Say, the,
Same. I need to verify them.
no, this is Vedram Lhare, na?
Laren.
So we had passed on around 23rd September 25. Meanwhile,
Make it absolute.
so we made,
Yeah, absolutely.
say, for the reasons recorded in our order dated so and so, passed on so and so date. The interim order dated 23rd September 25 is made absolute. On the same terms and conditions which we have imposed in the similarly, in the case of similarly placed petitioners co-accused. All right, that is also finished. Any other matter?
Means item 9.
Item 9.
9, my lords, I'm seeking 2 weeks' time to file a rejoinder. Their counter has come in only on Friday.
Means this is
2 weeks
same
after that.
matter as
My lord,
Ranu Sahu.
Hold on, my lords, they filed a counter affidavit. I'll come back.
This is same. He's
Not be arrested.
seeking similar omnibus prayer, my lords.
I want to file my rejoinder, my lords. I don't know why should there be a problem with that.
A similar
Lordships have
matter has
issued
been.
notice, my lords.
Prayers
It
are
takes them
similar
2
to that
weeks
as.
Come back in my this thing, my lords. They filed a counter on Friday.
You can approach the appropriate.
My lords, I've already approached the appropriate forum. I've come not in a direct 32 here. I've come against a 226 dismissal. So please give me 2 weeks, my lords. I'll come back in my rejoinder also. There are some new facts that they've taken. We'll respond back. So after 2 weeks, if your lordships allow.
No, the impugned order is declining bail or,
My lords, my
the
application
same way that
is rejecting.
Used under Article 30.
article.
Alternative remedy one, and then second saying that you should have either filed a quashing or you should have filed a anticipatory bail. Now, neither of them in my case will apply, my lords, and I'll point out why. I'm just taking 2 weeks' time, my lords, if your lordships will accommodate me only for 2 weeks.
So let me take up on.
Great.
What about 10?
My lords, in item 10, I am seeking a pass over, my lord. Item 10, I am seeking pass over.
Small player.
Huh? Maya Warrior. She can also be granted. He is there for the ED.
ED Lordship, I am appearing. I am led by Mr. Raju.
So she is a very small player as compared to.
Yes,
the-
but Lordship, if sees the prayer B does not exist because prayer B was not there in the special court's order. So prayer B does, because Lordship, the order that was granted bail said the conditions will be imposed by the special court. Special court has not imposed any condition that is pleaded in prayer B of the IA. So prayer A, I leave it to your Lordship if Lordship wishes, but prayer B
Some
doesn't.
more conditions to be imposed, sir.
That all in very stringent conditions we impose.
Yes, but Lordship, I am
Those
saying,
conditions will apply here also.
yes, but Lordship, if only comes to page 5. Prayer B says, direct the petitioner to report to the concerned police station, EOW, ACB, Raipur or any other police station once a month or fortnight. That condition was not imposed by the special court. So the condition that she is asking for waiver of is not in existence. That's what I'm pointing out.
Now, what is prayer number 5?
Prayer, page 5, Lordship comes to the IA for modification of bail condition.
Player B.
What is it?
There is an IA.
back to the concerned police station.
Yes, this condition was never imposed by the special court.
This was never imposed, so this is infructuous. No, sir.
Yes. Lordship will find the conditions that were imposed in page 13.
My lords,
No, but where is this condition imposed by us in the order of 6th of October?
Yes, Supreme Court by order dated 6th of October said conditions will be imposed by the trial court. Lordship will see that in page 9 of the same IA. The Lordship will see the conditions which were actually imposed by the special court in page 13.
No, but 6th of October is very short order by us.
The 13-14 is of conditions imposed.
These are conditions imposed by the trial court.
Trial,
Yes.
there is no condition of meeting the investigating officer.
Reporting. Which is the condition we say?
Sir, stay outside, stay away, submit affidavit, surrender his passport, and so on, so on.
Yes.
my lords, I
Mechanically it has come.
For the enforcement, appearing Sri Raju along with so and so on behalf of the enforcement directorate. From the interim order dated 6th October 2025 is made absolute, subject to the same terms and conditions as have been imposed by the special court, special judge,
Special Judge Dhan Sadan
this place,
6th Additional Session Judge Raipur, Chhattisgarh.
special judge in bracket Money Laundry Act, 6th additional session judge Raipur, wide order dated so and so.
7/10/2025.
70,
Order dated so and so.
7, 10, 20.
Grateful, Lords.
please.
Now your matters are over, please. Chhattisgarh.
One item is there. Please, Lordship.
14
is still left.
14? Okay, we'll see, just in 2 minutes, we are reaching the 5 minutes. Item 11?
11, I must at the outset apologize. My counter was filed a little late, but I have copies, my lord. I filed a counter for the state.
In item 11?
11.
Once for the state of Maharashtra state flat, counter affidavit has been filed, but the same is not attached to the, is not tagged with the paper book. Registered to do the needful. Next Monday? Next Monday,
Next one, I'm.
post the matter next Monday.
That is, I am grateful, my lord.
My lord, one request, my lord, if possible, may be kept on 18th. Monday, 16th. 18th is if possible.
All right, sir, we will comply with your direction. 18.
I'm grateful, obliged.
Yes.
Item 12, my lord.
Item 12.
12, my lords. Charge sheet was laid, my lord, in the year 2023. I appeared before the court, coming up after notice, my lord. I appeared before the court, executed the bond. Subsequently, on an application filed by defective complainant, one more charge was added. Therefore, my lord, my bail bond was cancelled. I moved for anticipatory bail. Sessions Court granted anticipatory bail. The Honorable High Court reversed it. So against which I am there, 2023, my lords. Violation of trademark.
Your anticipatory bail was cancelled. We have stayed that order.
Yes, ma'am.
He wants to make it absolute.
Grant.
My lord, they have not only misused my company's name, they've been selling poison to the public. High Court in its order, my lord, High Court has clearly said, where is that order? That is page number 198 of their SLP, my lord. High Court says that when they went for testing, they were absolutely unsafe for human consumption. My lord,
That's right, that for that, whatever the trial will take place, and if they are found guilty, obviously they will face
and
the.
I say, my lord,
consequences.
the bail was granted only on the ground that overlooking section 467.
That's
They said all the offences are, I apologize.
The best course for the state is that, the powers are very well there. They can seal the premises, they can close the premises where it is found that what is being manufactured is basically a poisonous substance. They can always do that. There are other provisions. That does not mean that criminal case will not continue. Criminal case will also continue. But for that preventive measure, they can take other steps.
My lord, High Court has said that you surrender and apply for regular bail.
State, and we hope that the state will.
Madam, I'm very for a state, madam. My only the legal submission is that once they have appeared and took regular bail, then the question of anticipatory bail is not there.
Bond was
They should go and take the regular bail. Who is going to
Bond was
stop?
cancelled, therefore we.
Well, we have heard learned senior counsels to counsel for the parties. Party. It seems to us that there do not exist sufficient and valid grounds on the basis of which the High Court could recall the order granting anticipatory bail to the petitioner. आपको लीव करके कर देना कि order satisfied करना है. Consequently, the appeal is allowed. The impugned order dated 17 December 25 is satisfied. It is directed that the appellant shall continue on bail, subject to same terms and conditions as already imposed during the pendency of the trial. Next paragraph. It is however clarified that the granting of anticipatory bail shall not be an impediment for the competent authority to take other preventive measures against the industrial unit if it is found that the product contains any poisonous or unhealthy substance. We have clarified that. Now we can.
No problem. Black.
Safety law को करना, food safety law में करना,
Under the
FSSAI.
Describe the authority.
I will come from that section. Next year, so I got. Okay.
Please, my lords. Let's, Please, my lords. Let's, despite this vicarious liability, my lords, I just explained that I've already undergone 9 months, my lords. If it is considered under section 26, that is violation of conditions of license, the maximum
Who
punishment.
is opposing from the respondent?
Don't argue that, sir. Don't argue all that drug and cosmetics.
Please, my lords, I'll argue on
With
merits.
regard to your complicity.
Kind of
yes.
medicine your partner is recommending, it is not under the drug and cosmetic.
Yes, ma'am.
Very easy to see.
No, I'm talking about 26 only. But NDP is 26. But on that, my lords, I'm not leaving that for the moment. On merits, my lords.
No, we
Who is
followed
appearing
the
for
sub-
this service they could.
So Dr.
Take my-
Malhotra had
Yes, he is true, my lords. And he was running. I'm only a silent part.
But we are surprised doctors are doing.
But my lords, Your Lordship, kindly see, there was no animus because in fact, they are searched.
In Punjab,
It's a malice. It has to be.
drug
addressed.
mafia includes.
Yes, it's a mafia.
People are making lucrative money, the doctors, the so-called industrialists, the police, and so many people are hand in glove. Unfortunately,
But one interesting thing, my lords, why this Malhotra might have done it, because the search in the pharmacy took place on 28th. Then thereafter, the search here took place on 2nd, next month. So even knowing that the search took place in the pharmacy, these people thought that this is nothing illegal here. Otherwise, they would have removed it. If they had some idea, Malhotra on paper, no person with a reasonable sense will not order for some.
Let us not open our mouth because it's for the prosecutor to move
Absolutely.
the case.
Absolutely.
But this was under the cover of using it as a medication. They were dealing with a Schedule H drug for which even the hospital does not have the license.
notice are not going to press.
Deeply obliged. Return to some early date may be given.
Trustee also.
Deeply obliged.
Notice देना. Notice देना है ऊपर देखो.
पहला फर्दर वाला है सर
Yeah.
14 है ना
Lordship, in item 14. But not one and point.
But for the state. I'm there in one. Password? No, not a password. Not a password.
14 का नोट है कैंसिलेशन
Well,
ये वो दूसरे वाला है सर ना 14 पहले 14 वाला बेल पे देना सर सर ये ग्राउंड्स पे बेल मिली है सर डिटेल ऑर्डर है सर वो कहते हैं कि नोटिस इशू कर दो नोटिस इशू ये बोलेंगे ना उसको स्टेट ऑफ छत्तीसगढ़
We'll take up this matter after some days.
At least notice may be issued.
no, my lord, I have serious objections to this. This was argued at great length. Your lordship will see the orders. Every contention has been considered.
My lord, that's my whole case. I'll point out in 2
No,
minutes.
I'll also point out.
Notice again, delay, my lord, at least
No.
it should be issued. I'll point out that none of my arguments
My lord.
have been considered. And my lord, there are some propositions of law, with the greatest respect to learned judge, my lord, which are not tenable.
It's a very
Your,
detailed order.
your lordship will see.
Detailed
50
order.
pages.
It's not a detailed order.
Can't be not a regular.
How can-
Against a bail order. It should be a ground.
My
for
lord, it is
cancellation.
not a detailed.
So now every order will come on an appeal like this.
59 pages of narration of facts.
Coming. In every case, my lord, this is.
Every aspect was considered, my lord, and at length for many days.
I thought it's my petition, my lord. I should be,
We are opposing your petition.
of course.
By saying this is the attitude of the.
Yes,
state,
yes, but I have-
we can report this court.
We'll show your
Not the
attitude.
first case, my lord. The lordship has done, my lord, so many of these cases.
Today, for some
No, no,
reason,
this
we are not saying anything for today for some reason.
Very well.
We'll take up this matter after a week or so.
Yes.
After 2 weeks, my lord, 1.2, difficult deal. After 2 weeks. my lord.
My lord, because this man has been released on bail, a vital witness is not attending anymore.
My lord, that in
Best-
fact
his
is an
best
issue
friend,
which
Manav,
needs to
a
be.
chap called Manav Saxena. Well, I'll point out what kind of,
You can bring those, so if any subsequent events.
Yes.
Because 2nd January means now more than 1 month.
yes, we will bring
If
that.
there are any visible subsequent events, you can place on report. Meanwhile.
One of the main grounds that vitiates it is, my lord, that
Lord,
this
they-
man's name was not mentioned in the FIR, therefore he should be granted.
Lord,
bail.
may I draw your lordship's attention, my lord chief justice. My lord, in 14.2, this is that lady Soumya Chaurasia. Soumya Chaurasia. My lord, she has been granted interim bail in a large number of cases by your lordship. my lord. She has spent 2.5 years in jail in and out. Your lordship asked her to stay out of the state. Now they have registered a fresh FIR in December this year, again relying upon material Milord of 2019, and she is arrested. I am requesting.
No, but December is much before we pass this order, last order.
Not fresh FIR.
December means much before.
No, I'm. Milord, arrest is in December. She has been arrested now in December. Milord, I am praying for interim bail. Milord, she has been granted interim bail by Lordship over the last 2 years.
But filed some petition, Mr. Rohit.
We have filed. It is listed 14.2, Milord. Notice was issued by Lordship.
14.2 and 14.3, Mr. S.V. Raju appears as
This is-
taking a passover.
In that liquor case. This is ED liquor.
14.1 and 14.2.
One is unrelated.
This is the 6th time she is arrested.
No,
5 times I have got.
14.2 is a writ petition under 32.
Yes. But I am saying this is Milord a evergreening of arrest. How many times Milord? 22, 24, 25, 6 times the Lordship granted her bail.
It's a writ petition. Anyway, there's no requirement to serve.
Milord,
Pick up your matter within a week, you file a petition there. The instant writ petition under Article 32 has been filed
Lordships have granted.
by the petitioner
Notice issue.
questioning the vires of section 44 of PMLA. However, we find that in substance, the petitioner is seeking her release on bail in a matter in which she has been arrested on, what is the date of arrest? On 16 December 25.
Yeah.
In relation to the liquor scam, has been arrested by Directorate of Enforcement in relation to liquor scam. Since the primary relief sought by the petitioner pertains to grant of bail, we relegate her to approach the High Court of Chhattisgarh. It may be Chhattisgarh. The petitioner, for my so advice, may file a petition. Within 1 week.
Yes, immediately.
In 1 week, the High Court is requested to take up the matter on out of turn basis, on priority basis, and make an endeavor to decide at the earliest, but not later than 2 weeks.
I'm very grateful.
But not
Very,
later than
very
2 weeks.
grateful.
The High Court will also keep in mind the various orders passed by this court, granting bail to the petitioner and other co-accused. This order.
14 and 14.1.
Milord, she has also been arrested by EOW now. So, Milord, your Lordship's Milord, observation may apply, Milord, there also.
She has been arrested by now, by EOW.
Milord, this was ED, what your Lordships have dictated.
Instead of ED, then
This was ED. Now, Milord, after that, she has been arrested, Milord, by EOW on 2nd of January 26.
we think that the petitioner has been further arrested in another case by
EOW,
EOW.
Chhattisgarh.
Economic
Offenses wing.
so and so. Then the petition may apply in both the matters.
Correct.
Then we will-
Grateful. I'm very good.
So my lord is placing 14 and 14.1 together on a separate date.
There's no connection, Manoj, please.
No, there's no connection. I agree.
You are going against-
14.1 was in relation to the evergreening of complaints, my lord, again and again, without seeking permission of the court. There was a point of law in that your lordship had.
No,
to
this
keep it.
is the first time I've heard of accused who themselves evergreen, now accusing the state of evergreen.
That is ED.
Yes.
That's ED, sir. You're not in that.
You're not, therefore.
In
what is
14
evergreen.
14 and 41, we can take
Yes.
together. No.
Can it be after 2 weeks, bro?
After 2 weeks or 10 days, give a date.
So grateful.
Both matters are 14 as well?
Both.
14 and 14.1 is filed by you.
Yes, bro.
That is ED matter.
That is the ED matter.
That is not your case, Mr.
That's
Jatnai.
14.1, but your lordship may keep them on separate dates.
No, 14 and 14, but don't tag them.
Don't tag,
mention as
that's
14.
that's my
all right.
14 or 15 like this.
Yes.
And be tagged and listed separately, but on the same day.
So grateful.
Obliged.
Grateful, Lord.
Please, my lord. Lord, pursuant to your lordship's order, my lord, of 27th of January, there is a fact-finding report, my lord, that the loss caused is only 3 lakh of rupees. And what
No,
the
no.
penalty sought to be imposed, my lord, is 12 lakhs, my lord. We leave it to your lordships, my lord.
This item 15, are you referring to?
Lord, if
what is
kindly
that?
have your lordship's order, my lord, of 27th of January 26, my lord. Last order. Issue notice, meanwhile, interim anticipatory bail is extended. However, Chief Secretary are directed to submit a tentative fact-finding report with respect to the loss caused to the state revenue, including in terms of the value of the illicit transported minerals, which is attributed to the petitioner. It is made clear the continuation of the bail will depend upon.
Well, is there any report filed?
Lord,
Yes,
that
Lord,
report
we
is
filed that
filed.
report, Lord. If your lordship has the fact-finding report, he, in this span of 2 months, Lord, he extracted about 4,314 tons of illegally mined this thing, minerals. And the total penalty which the state is to recover from him is about 12 lakhs.
According to you, the loss is 12 lakh.
12 lakhs, yes.
7,000.
This is the penalty, Lord, but this is apart from
Loss
the
is
fact.
3 lakhs. Loss is 3 lakhs. My penalty is 4 times, my lord, the loss. That your lordships will
You
get.
can afford to deposit without prejudice to your rights.
Lord, this is only
Lord,
small.
this
This is
man is
small
a
time, my
habitual
lord,
offender.
the transporter, my lord, guilty.
There is sometimes a presumption. The presumption is that the litigant who can afford to engage Mr. Devdutt Kamath
My lord, I'm sorry.
seems to be having capacity enough to deposit this fine amount.
Lord, he's
Lord,
a
the loss-
repeat offender, Lord. Earlier also, a penalty of 90 lakhs was imposed on him, Lord. Not only that, he was absconding. We had to issue
That
proclamation
excuse is
notices.
there. Nobody
He's
questions.
a flight risk as well, Lord. So I was only wondering, Lord, whether we
Like
lordships
that,
would ask
nothing
him
is said in the
to, now that the
affidavit.
charge
Sorry.
sheet has been filed, and the charge sheet discloses, Lord,
Huh?
the charge sheet now discloses that he used fake Ramanna papers, Lord, to transport.
Lord,
this.
I have lot to say on
And-
the charge sheet. After give me a.
No, charge sheet has been filed.
Charge sheet
Yes,
has
my
been
lord,
filed.
charge sheet is filed.
So the petitioner was denied pre-arrest bail, anticipatory bail by the High Court of Uttarakhand. While impugned order dated, leave granted, the appellant was denied anticipatory bail by the High Court of.
Lord, he was granted anticipatory bail, but only a
Only
time.
for
He
2
was
weeks, my
granted
lord.
anticipatory bail,
It was
but only for
limited-
15 days, so that he could seek regular bail. That was the bail. That's the
That
impugned
is
order.
completely contrary to
Correct,
lordship's judgment.
The, say like this, the High Court of Uttarakhand, while impugned order dated 30th December 2025, granted anticipatory bail to the appellant in case number so and so. However, limited the operation of that protection to the extent that limited the operation of that protection for a period of 15 days, meanwhile granting liberty to the appellant to approach the jurisdictional court for grant of regular bail. The aggrieved appellant has approached this court. Then say on 27th January 2026, the following and say in reference thereto, a fact-finding report has been submitted by the authorities, according to which the appellant is alleged to have caused total revenue loss of rupees 12,07,927 only.
Lord, 3 lakhs is the loss. Penalty, they say, it comes to 12 lakhs, my lord. Loss is only 3 lakhs.
So has caused loss of 3 lakh to the revenue.
No, that is not
along with
our
the
report.
penalty of rupees 12 lakhs only.
Page 6, my lord, of the.
Next paragraph. It is not in dispute that investigation is complete and charge sheet has been filed. So that being so, we are of the view that the appellant can be allowed to continue on pre-arrest bail, subject to however is depositing the amount tentatively the amount tentatively levied. The fine and penalty, subject to his deposit of the levied amount of fine and penalty. The appellant will deposit the requisite amount within 2 weeks, without prejudice to the rights of the parties.
Yes, ma'am.
Next paragraph. The appellant shall be at liberty to challenge the levy of penalty or the levy of fine or the penalty before an appropriate form in accordance with law, in accordance with law. Next paragraph. Similarly, the deposit of fine or penalty shall not absolve or exonerate the appellant from the penal consequences, if any, and so all these issues shall be, if any, should be, and thus the trial court will proceed against in accordance with law. The trial court shall proceed in accordance with the law.
Lord, the conditions
So your
imposed,
lordships may
the
consider-
conditions imposed by the High Court will continue, Lord. So your lordships may, the conditions imposed by the High Court for grant of bail, those will stand incorporated by your lordship's order as well, Lord.
The appeal
On the
is
same
allowed
condition.
before one change order of the High Court is set aside.
My lord, the only request is whatever your lordships have
Appeal
said,
is allowed in about terms.
whatever your lordships have said, my lord. Lord, my lordships may say that not affect the merits of the case, my lord, because ultimately.
Goes without saying.
Clarified that we have not expressed any opinion on merits of the case.
Extremely grateful.
I'm grateful.
Item 16.
May it please, Mr. Lord said, directed me to inquire about the antecedent of this, the petition. My lord, there are none.
No antecedent.
That was the only.
No antecedent. He got money in respect of online fraud, but
The appellant is agreed by order dated 11/12/25 past 12. The High Court of Chhattisgarh at Bilaspur, declining him bail in FIR number 157/2025, registered at Police Station Raipur under section 111, 317 in bracket 2 and 317 in bracket 4, 317 in bracket 5 of BNS 2023. The appellant was arrested on 6/10/2025. The allegations are that during the period 26 June 2025 to 6 July 2025, the appellants co-accused, Vishal Bekra, operated multiple bank accounts through which online fraudulent transactions aggregating approximately rupees 9.45 lakhs were received. The appellant is alleged to have assisted the above named co-accused by providing a mule account, and he received a share of the proceeds in cash. Next paragraph. Having regard to the nature of allegation and the period spent by the appellant in custody, or without expressing any opinion on merits, the instant appeal is allowed. The influence order of the High Court is satisfied, and the appellant is directed to be released on bail, subject to his finishing bail bond to settle the trial court. He is to be back to bail appeal. You are still NFP?
No, my lords, I'm in custody, my lords.
No. If suppose you like the jail premises or the jail atmosphere environment, then we can dismiss the petition. We can allow you to stay in jail if you want. Otherwise, we have by mistake granted bail to you. You want to be on bail or you don't want?
My lords, I want bail, madam.
Then you should go by with a smiling face from court. Why you are so showing as if you are under depression?
Okay.
Thank you, young lady. Thank you. Item 18.
My lord, item 17, my lord.
just for just
17 minutes.
My lord, 17, my lord. I am praying for bail, my lord.
17. Come here. Or 17 also.
Yes, my lord.
Oh, you are the main accused. This main
He's
accused.
the main accused, my lord.
My lord, I am. My lord,
इसको bail दे दो.
my lord,
अभी तो छोटी मोटी चोरी केस है.
Same reasons, my lord.
My lord has granted me bail.
अरे दे दी भैया बेल दे दी क्या साहब आपसे डर लगता है पहले item 18
My lord, bail was denied to me while granting bail to others. For me, my lord, bail was denied because I happen to be closely related to A7. So he is absconding, he applied for anticipatory bail. Disciplinary reason given, your Lordship, kindly come to page 31. Long incarceration.
The main.
How much you have made money, sir? As per the allegation?
732 crores.
Only.
A7 is the shell company. Owner of
Lordship,
the
kindly come to page 31, my lord.
not
But long incarceration is the only ground.
9 months only.
My lord,
9
10 months now.
only.
Now 10 months, almost 10 months.
For 700 crores, 9 months.
Look at
That
the
is, that's what they say. I will not want to go into the merits of the matter now.
Look at the eminent position and the seat of power you have enjoyed. There is a direct nexus between the allegations attributed to you and the position you held for a long time.
But I will.
And you are not an ordinary and small kind of person.
But
And after investigation, there are definite allegations against you of taking a huge amount of bribe and
I will not.
visible in your accounts or in your known sources.
But at this stage, I do not want to go into the merits of the matter. At this stage, but I will argue the matter on merits when they file their counter. No, for the present, I will submit. All the other accused, most of the accused similarly placed granted bail on the same ground.
We have also granted, bail, we are aware, but not, those were very, very small fries.
No, same thing, same. Your Lordship, kindly see, so far as accused number 34 is concerned with the similar or graver allegations. All. Almost all according to the case, all acted.
The order, page 31 of the order.
Not only me. The others also similarly placed, they have been granted bail. Yes, Murad. Yes, Murad. But so far accused number 1 is concerned, closely related to Murad, determining factor, closely related to A7 who is absconding now. Another influential supervisory role, that's all. For the next man, investigation substantially complete, no direct recovery, risk of absconding or tampering not shown, role more facilitative than controlling. Then next man merits. Investigation complete, co-accused with similar or graver allegations granted bail, prolonged detention would be pre-trial punishment. Same. The next man charge.
You are the central conspirator, first of all.
No, I.
Central conspirator.
Your Lordship,
Orchestrated liquor policy, influenced obvious allocations, promoted blue-eyed brands.
Your Lordship, kindly come to.
Selected
I will.
kickbacks of 50 to 60 crores.
Your Lordship, kindly come to Murad's page, paragraph 44, page 24. Murad, the allegations against me have been, almost similar allegations against others also. Charge sheet has been laid. I have been in prison for 10 months.
No,
kindly see.
allegation against him is 732 crores.
That's right. Your Lordship, kindly come to paragraph 44 of the order, page 24.
Nagamothu,
My lord.
the shell company in which 750 crore was parked, as per paragraph 45 you indicated, is in your direct control through A7.
No.
This is the prosecution case. Now, if you accept that, you stand clearly on a different footing to A6, A34.
I will show Millard the other accused for whom bail was granted. Millard, the graver offences than me. Millard, they are also.
Wait for some time, Mr.
Millard, for the present, Millard, my submission would be Millard. Millard, let them file counter. Millard, I will take your Lordship, Millard, and place records also to show that absolutely, Millard, there is nothing against me, Millard, and these allegations are very minor.
At best, you can make out a case for cancellation of bail granted to some others, but that will not help you in getting bail.
Millard, that matter is pending before this honorable court. Your Lordship, kindly take this along with that. Your Lordship, kindly see, Millard, in respect of some other accused, Millard, bail was granted, challenged before the court, pending, your Lordship have granted stay of that. High Court cancelled, Millard, your Lordship have granted stay. That is also pending before your Lordship.
No, those were
That matters disposed of.
They have disposed of.
There was question of statutory bail. We said that without going into that question, they will remain on interim bail and the issue will be decided on merits.
Well, if your Lordships, Millard, decide to go into the merits of the matter, my lord, I may need some time. My lord, may kindly have it, my lord, this Friday. My lord, I will argue elaborately, my lord. I do not want to waste the time on this on today. My lord, may kindly have it that Friday. I will argue, my lord, elaborately, my lord, and demonstrate.
Friday, how does it matter, Mr. Nagmuthu?
My lord,
Monday or Friday, how does it matter? You can argue today whatever you want to argue.
my lord, today, my lord, may kindly consider to
We
take.
are not inclined to release him on bail at this stage.
My lord,
If
I
you
got
want
some.
to argue on merits, you are welcome. We can't stop. But please, you will not invite any observations from us on merits also. Today, we are only simply to say, at this stage, we are not inclined. After the examination of some of the vital witnesses who have direct bearing on your accusation against you, liberty to apply afresh before the High Court.
Your Lordship, may kindly, at least your Lordship, may kindly have it tomorrow. I will argue the matter elaborately. Your Lordship, may kindly, for my sake, your Lordship, may kindly have it tomorrow. I will argue the matter elaborately. Tomorrow, my lord, at least. Or subject to my lord's convenience any day. My lord. Any day subject to my lord's convenience. Tomorrow is in case for your lordship. Your Lordship, may kindly have it any day. I will argue the matter elaborately. My lord. Any day. I am not asking for any.
Now tell us
Any day, my lord. Friday, this Friday, my lord, subject to my.
before Friday, will not Friday.
Any day, my lord, subject to my lord's convenience. Any day.
Before Friday, you tell us onward. Day after, Wednesday.
Tomorrow, my lord. Tomorrow, my lord. Tomorrow, my lord.
Day after we are arguing.
Day after tomorrow, I'm not here.
On Thursday?
Thursday.
All right, Thursday.
Thursday. Good.
No. Yeah, that's it.
Now, Lord, Lord, this is a case, Lord, where a closure is ordered of a chemical factory. Now, Lord, this is not a case where the factory is deficient in any manner. We are functioning for 10 years. We are fully compliant. The allegation is that, Lord, we have to dispose of spent hydrochloride acid, which we use for manufacturing, Lord, an intermediary product.
There, Mr. Rodgi, deputy.
We're discharging the acid in Narmada Canal.
In the Narmada Canal.
So what has happened is this, Lord, I have to use an approved vendor, which is, Lord, a transporter, approved by the Gujarat Pollution Board. I can't use any truck I like. I have been using an approved vendor, Lord, for 5 years. They have made more than 500 trips. There has never been a problem. It has to be disposed of in that man's factory, Lord. That's how the hazardous rules provide. Now, Lord, I accept what has happened. Apparently, this driver on this trip did not take, Lord, the product to the factory concerned for disposal, which has been going on. Apparently, Lord, the allegation is he disposed of in a canal, etc. Now, if that is so, Lord, there can be some penalty. The penalty can't be that you, Lord, throw the baby with the bathwater.
No, we are not saying that.
What wrong has I done? I have chosen, Lord, a vendor approved by you. The driver went elsewhere.
The point is, Mr. Rodgi, that whatever mechanism you had for disposal of
yes,
that has been found to be faulty.
No.
It is faulty because they don't have control. Once the material, this liquid goes from your factory premises
to another factory. Yes.
You don't have any physical control on this driver because you have hired an agency. And assuming this truck is caught, we do not know how many trucks went unnoticed.
Lord, I'll answer that. It can't be because the actual live movement of a truck approved vendor under the hazard rules is, Lord, on a website which is alive and, Lord,
Mr. Rodgi, please see.
it is GPS enabled.
It's a question of life for millions of people.
I agree. Lord, I can show you. Show me
the only source of drinking water in that space.
Lord, I am not saying no. I am saying, Lord, if it has happened, the remedy can't be closure.
We are not saying that. Your remedy will be that you will have to satisfy the NGT that what kind of preventive measure you will take. It will be a scheme.
Lord, Show me that movement. Physical movement.
So page 7.
My lord,
Page 7.
my lord, your lordship is perfectly right. I will show you, my lord, that there is a live GPS of every truck with this number moving, my lord, on a screen, going from A to B. When I saw it myself, there was some diversion, my lord, of that truck. That is, my lord, this is how it is done by GPS.
This you can show to the NGT also.
No, I only wanted to say, my lord, this man may be remiss. This is how, my lord, it goes. This man may be remiss. 1 out of 500, my lord, trucks may be remiss. I am not saying no. But the remedy can't be to order a closure of the factory. You may have some penalty, something. I can understand.
We are not saying at all that what should be the proportionate person.
Correct.
You are entitled to argue on the doctrine of proportionality that you can, but you can argue it before NGT.
Proportionality, I agree, my lord. Proportionality is if I have committed something wrong. My lord, I have chosen a vendor. What else can I do?
Under the hazardous rules, Mr. Ruadgi, it is, the vendor is considered to be your agent under the
But approved by them.
extended product liability.
Correct, but approved by them. What else can a man do? My lord, some penalty, yes, but
The Honorable Chief Justice indicated to you that it is a question maybe of proportionality in the embargo or the interdict.
if I am remiss,
By NGT, once you will submit a scheme to the NGT, that yes, this mistake or lapse has happened, but to prevent it, that and to ensure that there is no violation in future, this is my scheme.
and this is what I am doing, my lord, for the last 10 years.
The tribunal will consider that.
Only one more request, My lord, now the order has come. That day the order wasn't there when he mentioned, my lord. The order, my lord, of the High Court has come now. Have a look at that, see the last portion. I want to make one submission there. I filed that order separately, my lord, it wasn't there.
It's impugned.
It is now impugned, yeah.
Part of the,
See page 15, last portion, my lord.
para 23, yes.
Yes. Liberty rests with the petitioner to approach the pollution board for seeking
Gujarat, State Pollution Control Board.
Yes,
Yeah.
to seek revocation or go to NGT, my lord, and these observations will not come the way, etc. Now, I only want to state, my lord, on 5th of February, I have gone to them. That, my lord, representation is pending.
We can direct them to decide.
Only one thing, my lord. Till then, the closure, my lord, should be in abeyance. Why should I be closed?
That part.
No, even if you decide in 1 week, my lord, your lordships consider a man who's not remiss on his own factory is not remiss, my lord.
You simply tell us that have you approached the state control policy?
Yes, I have approached them on 5th of February. I have placed it on record. And I wanted a stay. That's why you mentioned to my lord the Chief Justice on Friday.
No, we can simply direct the Pollution Control Board to decide that matter within a week.
After giving me an oral hearing, my lord, I will show them this. Number. But till then, my lord, there should be no coercive steps. My lord, what is the advantage? I produce, my lord, for anesthesia. I give it to the government. I give it to all that. There has never been, my lord, a remiss position of this factory for 10 years.
You see, sometimes the harsh actions are required to be taken to convey a very stern message to everyone.
I understand that.
You can't play with the environment like this. That is only maybe.
But my lord, to paint me black because one black sheep may have been remiss is too harsh, my lord, for a closure. I employ 500 people, my lord. I have never been remiss. There is not a single instrument, my lord, equipment which is not installed. Consider, my lord.
They can consider the main matter.
Just consider this, my lord. Every day, your lordships have cases where there is affluent flowing from factories.
Operating a manufacturing unit at the Dahej in Brackwood, Gujarat. Spent hydrochloric acid.
Yes, spent.
In bracket, spent HCl is generated by the petitioner's industrial unit as a byproduct. According to the petitioner, that spent HCl is supplied to an authorized actual user. However, on 29th January 2026, a tanker bearing number GJ dash 27 dash TG dash 6676 loaded with 34.170 metric ton empty of spent HCl is departing from the petitioner's industrial unit, a factory, on 30th January 2026. Was found to have thrown that spent HCl in Narmada Canal. This prompted the Gujarat Pollution Control Board
Not only, sorry, only for,
take an action under section 33 capital A.
only one interruption, Lord. They gave me a show cause notice asking for a reply in 3 days, but without waiting for that, they closed me the next day.
We also closed, my lord, the other side. The other entity where they were receiving HCl, we found that they have not received HCl. What happens is, for them, it's a byproduct. For another company, it is a raw material.
But Your Lordship may say it's an allegation. I don't admit that he has done this, he has done that.
Pollution Control Board is said to have found from Messrs. Sri Ramnath Chemical
Yes.
that the spent HCl was not received by them. The spent HCl in a roasted truck was not received.
Lord, we dispute this proposition. We dispute this, that it was diverted or that, my Lord, he didn't receive it. I dispute it.
Was alleged
I'll show it to you.
received by them. There is further allegation that it was thrown in Narmada Canal. Be that as it may, the Gujarat Pollution Control Board issued a show cause notice and thereafter has passed an order.
Issued a show cause notice for 3 days, but
My Lord, they did not wait for my reply. They passed the order the next day. That is one breach.
To, invoked its powers under section 33 capital A of the Water Prevention Bracket
33A2.
33A2
Yes.
of the Water in Bracket Prevention and Control of Pollution Act 1974 and issued a closure order dated 3rd February 2026
avoid grave injury to the environment.
On the ground of avoiding grave injury to the environment. Next paragraph. The above stated order was challenged by the petitioner before the Gujarat High Court, before the High Court of Gujarat. However, the petitioner's petition has been dismissed by the High Court, while the impugned judgment dated 5th February 2026 with the following liberty. Reproduced para 23. Next paragraph. The aggrieved petition is before us. At the outset, it is pointed out by Sri Mukul Rohtage, learned senior counsel for the petitioner, that in deference to the directions contained in deference to the liberty contained in para 23 above, the petitioner has filed a statutory appeal.
No, my Lord. A representation.
Petitioner filed a reply to the show cause notice come
No,
representation.
actually, my Lord,
Sir,
show cause is now
revocation
over. I made a representation on 5th of February before GPCB, on 6th of February.
Has made a representation to the State Pollution Control Board seeking recall of
Yes.
Revocation, my lord, it's called revocation. Revocation.
Revocation of the closure.
seeking revocation of the closure order dated 3rd February
My lord.
2026. Yes, sir. That being so, we deem it appropriate to dispose of this special petition with the following directions, stroke liberties. One, the prescribed authority in Gujarat Pollution Control Board is directed to take an appropriate decision on the prayer or stroke interim stay made by the petitioner in its representation within a week. Within a week, please do. The interim order 2I, the interim order of any nature may be passed pending the final order on the representation, which may be decided. Do we need one order is sufficient?
No, dear Lordship, because that would mean that we have to pass some interim order.
Milord,
We will decide, Milord, finally one.
but for 1 week, please don't close it. That's all I'm saying.
To decide the representation within 1 week.
After giving me an opportunity, Milord.
After hearing an opportunity of being heard.
Personally, yeah.
The petitioner's representative,
Yeah.
authorized representative. Next paragraph. The aggrieved party shall be at liberty to approach the National Green Tribunal. There may be a separate prayer for interim directions before the National Green Tribunal, and in that event, such a prayer of the aggrieved party shall be decided by the tribunal as early as possible and preferably within 2 weeks, subject to the pending appeal, subject to the outcome of the pending appeal.
Good.
Please.
Good.
Obliged.
Item 44.
Yeah, please, Your Lordship. Your Lordship, I've been in custody for around 269 days, and similar co-accused have been granted bail.
But in your case, notice has not been issued so far.
Sorry.
That's matter.
Notice, no. Fresh.
We have granted bail to your co-accused,
Yes,
but
that's
then we have to issue notice in your.
That's correct, Your
Issue
Lordship.
notice, trustee. Are you there?
I appear on advance notice, Your Lordship.
You are for the state.
Yes, please.
Then say, Madam, accept notice on behalf of the state of Chhattisgarh. We have already released the co-accused.
Yes,
Do you want to file reply or we can release him also?
We want to file a reply.
You want to file reply? Then do it by Friday. File a short reply. We have next Monday.
Oblige, Your Lordship.
Counter affidavit to be with advance copy to content for the petition post to content.
Obliged.
May I please? This is also fresh. Now 9 months, 9 years, 7 months, I have completed out of a term sentence of 10 years. Well, the High Court says that period of incarceration is not the sole criteria. Well, if I'm going to complete the entire sentence while my appeal is pending, with great respect, my lords, it can't be that my appeal will be rendered infructuous as far as this is concerned. Please see the custody certificate, my lords, at page 446.
Well, your appeal is of 2020.
Yeah, my appeal is of 2020. Out of the sentence that is there, I have already undergone 9 years, 7 months. 10 years is the sentence that is imposed on me. 9 years, 7 months I've undergone. Another 5 months, 6 months, I would have undergone the entire period of sentence. Entire period of 10 years I would have undergone. And the High Court says, my lord, that this is not the criteria.
7 years for 9 years. How can it?
7 years is actual, 7 years is actual, 6 months, 7 years, 6 months. Then they was added a remission period.
Remission is available in this kind of.
Remission is
There are no
available.
remission. It has to be actual sentence only.
Is listed on 11th for hearing.
With respect.
Appeal is listed on 11th for hearing.
See, I thought to decide the appeal.
Solicitor. Why not an appeal for converting it to 302?
Because there is,
Huh?
I have filed an application
Yes.
regarding that.
But the victim has filed.
We have, that's also pending.
You consider that, Mr. David?
With respect, but today there is no appeal.
There is an appeal.
There is no appeal. Please see the cause title. There is no appeal, my lord. There is. Please,
No.
my
We
learned
are not
colleague-
concerned with cause titles, Mr. David. Is the victim here before us
No,
who's
if
saying
there-
has filed an
my lord,
appeal?
if there is an appeal, it would have been taken up with the same matter many.
But we don't wish to comment.
But
Give the
where is
number
the
of the appeal to Mr. David so that he is better advised.
I'm not, my lord, today,
Please, you get the number of the appeal under appearance.
which appeal, my lord, with great respect, there is no
Out
appeal
of-
on this matter.
Out of 10 years or so, whatever sentence that has been awarded by the trial court.
Yes, my lord.
You have undergone actual sentence of 7 years and 9 months or so,
Yes.
right? Less than 8 years.
Yes.
It is highly debatable whether an offense involving moral turpitude of such a nature,
Yes, my lord.
will you be entitled to claim any remission?
Yes, my lords, of course.
Anyway,
can claim
we
commission.
are not saying, we
Remission
are
is a-
saying highly debatable.
Because remission is available even in murder cases, but after 14 years, you have to undergo 14
Murder
actual
case
14.
can be, you see, murder case can be sometimes a simpliciter murder.
But this
case.
is a murder
So the
case
two
only.
groups are fighting out of certain on momentary issues, sometimes without any intention, sometimes it takes place, or it can happen. There are several
The
circumstances.
remission policy of Delhi government is clear. This is a term sentence of 10
Anyway,
years.
that issue becomes academic in the sense, once the learned solicitor is pointing out that your appeal is coming for hearing
On 11th.
on.
11th.
Yeah.
It was listed
So
on
we'll
third.
request the High Court, to take up your appeal on day-to-day basis. They are not opposing it, they will argue from their side. Prosecution will also extend full cooperation.
Victims appeal.
No, this is, I'm with great respect.
And
I have yet to come across a case where a person has undergone out of 10 with remission, with remission also 7 years, without remission also 7 years.
Yes.
And that
The-
no
yes.
suspension is granted to him.
Mr. Dave, the total period undergone by a convict is undoubtedly a factor that is kept in view while suspending the sentence. But why we suspend the sentence? Only when we are uncertain about the time that will be taken in the final decision of an appeal. Here is a case where the main appeal has been listed for final hearing. What is required to doubt to remove any kind of cloud on that certainty, we will request the High Court.
It was listed on third, as per the impugned order, it was listed on third, not taken up on third.
Why?
Because
Why
your
must not have been taken up? Because somebody must have pointed out that your SLP is coming before this
Nobody
court.
pointed it
There
out.
is a difference. There is a
No,
difference.
this is with respect, Manoj.
Mr. Dave,
This goes to Article
Mr. Dave,
21.
right from all high courts in this country, including the Supreme Court, we have two categorization of two sets of criminal appeals before us, where the accused is on bail. We do not grant out of turn hearing in those matters because we know that there is no crisis of liberty. Bail have been granted. But in the cases where we do not deem it appropriate to release an accused on bail, that's a separate set of category where the appeals are taken out of turn. If your is a case, 2020 appeal might not be ordinarily, it will not come as per turn in Delhi High Court. But because you are there you have not been granted bail, that's why the High Court is according you out of turn hearing. And we will cement that, we will further request the High Court, making it sure that your appeal is heard.
Appeal, it may be heard.
Lord, another
Well,
thing.
just 1 minute, my learned friend.
Lady
Please,
is undergoing a life imprisonment in the second offense.
So what difference does
So
it
whether,
make?
my lord,
So I should not
it's
get
here
bail.
or not, my lord, doesn't make any difference.
Every time the argument is even better. Now, please see if for a 10-year term sentence, suppose it was not 304 part 2, suppose it was 307, attempt to life 10 years I've got. Would it still be that I'm not entitled to remission?
We are not required to look into these aspects. We are not saying, you see, as an accused, you see, this is one country who is so proud of on rule of law that even the most heinous, dreaded criminals, we have been according opportunity of hearing. This country has followed the rule of law. This country has provided a fair trial, even to the dreadest anti-nationalist elements, even terrorists.
Kasab was,
So even a person, as Solicitor is pointing out, a person who came attacked so brutally on the integrity of this sovereignty of this country, we even provided fair trial to him
the
also.
offense was seen by the world on television.
What does my learned friend? I am not discussing the Kasab matter. I don't know why my learned friend is on Kasab.
In
This is
your
not a
case
Kasab
also,
matter.
he is only illustratively telling that in the
This
worst
time
cases
link
also.
me to Kasab. What do I have to do? I was a
You have
sitting
to do
MLA.
nothing. You have to seek an assurance from the court of law that irrespective of the nature of allegations, irrespective of anything coming in media, you are entitled to a dispassionate hearing of your criminal appeal by the High Court, which will be decided without being influenced by here and there anything, which should strictly confine to the evidence on record, material on record. That's all.
So now, may I just answer one question which fell from my Lord Justice Bagchi. My learned friend says he has filed an appeal. That appeal is for necessarily enhancement of sentence. It can't be for anything else. It has to be enhancement of sentence or change, or that it goes under 302.
Why not? Why not?
It
It's
goes to
302 charge was framed against you, 102
I'm assuming against myself.
So there is a lesser offense on which you have been convicted. Why so to the?
Just bear with me for the submission.
Yes, you can bear with you for a lifetime, Mr. Dave.
The enhanced sentence could also be death in that.
May I
in
just
my application.
indicate why I'm making this submission? If it is my learned friend's appeal, it goes to DB. This matter is before a single judge, it's below 10 life sentence, then it cannot, no, I'm saying if it is fixed on 11.
In appropriate cases, Mr. Dave, this sort of an appeal where there is a possibility of a appeal by the victim for enhancement, not a case for a division bench.
There's no point, Manoj, for 11,
Mr. Dave,
Loses one.
nobody is arguing this. I don't know why the solicitor has not preferred any appeal in this matter. The CBI is sitting pretty.
This is not a case of any quorum non judice plea. These are all internal arrangements by the.
Are asking the High Court to expedite the appeal.
So therefore, in the case, suppose a division bench of the High Court, suppose prima facie feel that the appeal filed by the victim also should be heard along with your appeal. In that case, matter has to be listed before a two-judge bench.
So it can't be heard on the 11th in any case. Since much submissions were made, it's listed on 11th, hear it on 11th, have it on day to day. The other side is saying, though, it can't be heard. That's what I'm all pointing at. The only thing I was pointing out.
Can be taken up on some.
So, Manoj, 10 years, assuming that he goes through his 10-year sentence, Manoj, his appeal would be infructuous. And if their appeal is dismissed, he's undergone the entire sentence.
Kind of whatever doubts you have in mind about listing, that we will clarify here. Both sides.
I'm saying, Manoj, if
Both sides are present before us, so
in 9 months, 7 months are not enough. If 9 months, 7 years are not enough.
as well as their.
We were not even charge sheeted in for murder by the CBI. It was a club trial, therefore.
We are not charging.
Look, may I just say,
Initial.
this.
So I'm only saying, Manoj, 9 years, 7 months undergone. With remission, another 5 months I have to undergo. I will undergo that period. There is nothing else that is left. Whether the appeal is heard or not becomes an academic question. Only if their appeal gets allowed.
There is no criminal appeal becomes an academic issue. Even in those cases where unfortunately the persons died while pending the criminal appeal, because the family is still entitled to seek vindication of innocence. If there is an innocent person falsely or erroneously convicted by the trial court. So these are nothing to do completion of sentence, anything. These are not the circumstances.
Out of 10 years, 9 years, 7 months in custody or 7 years actual custody is more than 7 years.
We appreciate your contention. Therefore, request the High Court. Request the High Court to decide your appeal.
If I had come in any ordinary case, Manoj, I would have got bail. With respect, I'm just saying so, Manoj. When it came, the other matter came before your
jail for
last 1 minute. My the solicitor is not. There no notice is issued in this matter. Now, because that other matter when it came, we said that this is it fell from the Honorable Chief Justice that you are not released in that matter. Therefore, we are staying that matter in the bail in that matter. When we come in this matter, the solicitor says in that matter you are in custody. So how does it matter? Somewhere I have to start getting bail, or I'm going to be just in arguing my appeal or pursuing my appeal. And now the complaint.
We have already explained that in a case of conviction and pending criminal appeal, what are the parameters normally we follow on uniform basis in all high courts and including the Supreme Court.
Yes.
Where the accused is inside and has not been released on bail, he or she is entitled to an out of turn hearing of the criminal appeal, so that at least before completion of the sentence, the matter is heard. That is the principle followed. In your case also, there cannot be any exception. You are entitled to whatever you are entitled to law, you must get it.
Yes.
Therefore, you are entitled to an out of turn hearing that the High Court is according. We will also make sure that you get it.
But that process is not available, Manoj, because now the complainant feels that I should be convicted under 302. So his appeal first has to be.
Mr. Dave, for deciding your
365.
For deciding your appeal, we cannot gag the right of a victim. If at all there is a right in law.
Mine also, Manoj.
Yes, so therefore balancing has to be done.
For 9 years, 7 months.
We are absolutely right to do, but there has to be a balance of rights.
I've undergone more than half of this actual sentence. Actually, I've undergone more than half, Manoj. Kindly consider this. In which case, for term sentence, this is not a life imprisonment. Life imprisonment, I can understand the High Court has some leeway. Your Lordship may have some leeway that it's a life sentence. There is no term there. But in a term sentence, Manoj, your Lordship always takes into account the period.
It is a term sentence of a person who has been convicted and sentenced to life imprisonment in another case.
Yes, my lord.
Isn't that a relevant consideration for suspension of
When that matter came up, my lord, the same argument was there that please stay.
Certainly, one will color the other.
So,
if there are, why do we speak of criminal antecedent? when it comes to a question of multiple cases against an individual, courts are generally circumspect in granting
Same incident.
pre-conviction bail.
Same incident. It is not a separate.
No, it's
incident.
definitely not the same
It's the
incident.
same- Exactly.
It's the
same
motive,
incident,
it's
my
the
lord.
motive.
Allow me to.
The rape case is the motive for this crime.
In this case, here the person died in police custody. Person died in police custody. I was
Two
not.
police officers have been convicted.
Yes, my lord. And I have been with 120B. I was in Delhi. Those are the findings. I can show. those.
Let us not comment on the merits.
Mr. Dave, any argument touching the merits from your side will invite a reaction from our side unnecessarily. And you know this matter that unfortunately it's not that we are not sitting in ivory tower. We know that there is a media trial also going on, which we do not really approve. And the way Mr. Prachap outside the court, he goes to the media. If you are a consul, you have no business to go there. Don't forget, I have saved you in profession. Your license would have been suspended, your exemplary costs were imposed on you by the High Court. I saved you thinking that you will believe in professional ethics. You have no business to go to media when you are appearing in a case here. If you find that you are indulging in this kind of drama, then you will face the consequences also.
Can I just say?
As a Chief Justice of India, I can't tolerate these things.
Let's kindly see what the other side.
You are arguing here, you are conducting a parallel trial outside the court. This is not acceptable.
I was just informed.
We are only warning you today, you take this warning in the right earnest, that's all.
Can I also say this, that please tell this to the other side?
Right now.
What
They have.
side? I never went and gave interview in the
Now,
other side.
we have conveyed our message. And anybody knowing that how I function, I hope that people will believe it and follow it.
May I just say?
Then may I only suggest.
Do not invite any
Let the
consequences, that's
DB
all.
take a call whether his appeal is maintainable or let the
The
DB.
other side also.
You have a right to oppose, he has a right to
No,
argue.
I'm saying let the.
You will argue in court, that's all.
Because the division bench, since your lordships are asking for expeditious, let the DB first decide whether his appeal is any merit in it or not, then call for my appeal.
The way that you will argue before division bench of the High
Leave
Court,
that-
not before us.
Expedite, then I'm only praying, don't expedite this simpliciter, my lords, my matter. Because
All
it will be tied up with the division bench matter.
Right now. The petitioner say leave granted. The appellant is agreed by an order dated 19th January 2026. Passed by the High Court of Delhi, declining his prayer for suspension of sentence and consequently release on bail in criminal CRLA number 539/2020. Declining his application under section 389 in bracket 3 CRPC, seeking suspension of sentence and so on. The above stated criminal appeal has been directed against a judgment dated 4th March 2020 of the trial court, by which the appellant was convicted for offences under sections 166, 167, 193, 201, 203, stroke 21, stroke 21, 212, stroke 323, 341, 304, 120 capital B IPC, and sections 3 stroke 25 of the Arms Act. We just make sure that correction in this section. He was consequently sentenced to undergo a rigorous imprisonment of 10 years.
Yes, my
10
lord.
years.
Highest is 10 years amongst all of them. The highest sentence amongst all of them is 10 years.
Terms, maximum of which
He
was.
was a maximum tenure of maximum RI for 10 years, though different sentences were awarded for different offences. those separate sentences were awarded for different sentences, offences.
And all directed to run concurrently, my lord.
Next paragraph. It seems that the appellant, besides arguing, besides making an attempt, a case for suspension of sentence and release of bail on merits, also vehemently urged before the High Court that he has already undergone an actual sentence of 7 years and 9 months out of the total sentence.
With
And-
remissions, with remissions.
Huh?
7 years, 6 months, 29 days with actual. My learned friend is not aware since I'm in custody, and 9 years, 7 months with remission. So 7 years and 7 years and 7 months of actual custody.
7 years or 7 months of actual sentence. Anyway, that's a matter of calculation.
No, it's there, my lord, at
Next paragraph.
46.
The High Court has wide impugned order. One line, the appellant also urged that some of his co-accused had already been released on bail after suspending their sentence. Wide orders dated 22nd September 2023 and 17th October 2023. The High Court, however, wide impugned order has declined the suspension sentence and consequential release on bail, entirely observing that the appellant is already serving a life sentence for the rape of the deceased minor daughter in a connected case, semicolon, that his previous application for suspension sentence was dismissed on 7th June 2024, and there are no new exceptional or compelling circumstances, etc., etc. Next paragraph. The agreed appellant is before us. Next paragraph. At the outset, it is pointed out by Sri Tushar Mehta, Learned Solicitor General of India, representing the Central Bureau of Investigation, that criminal appeal, criminal LA number 539/2020 of the appellant's criminal LA number so and so is now listed for hearing before the High Court on, what is the date, otherwise?
11th.
On 11th February 2026. He thus submits that the High Court can be requested to take up that appeal, to take up and decide that appeal on out of turn basis. Can may be requested to take up and decide that appeal on merits, on out of turn basis. Next paragraph. At this juncture, counsel for the victim states that the complainant side has also filed an appeal challenging the trial court judgment dated 4th March 2020 on various grounds, including on the question of quantum of sentence. Next paragraph.
Which is pending before the division bench.
Since there is no reference to that appeal in the impugned order of the High Court, we do not express any opinion in relation thereto. Next paragraph. Keeping all the attendant circumstances of the case, especially the period of sentence already undergone by the appellant, we deem it a fit case for requesting the High Court to accord out of turn hearing in criminal LA number 539 of 2020 and decide the same as early as possible, but not later than 3 months. but not later than 3 months. Next paragraph. As regard to the criminal appeal, if any, filed by the complainant party stroke victim, we grant liberty to the appellant in that case to approach the High Court for taking up of that appeal for hearing. Full stop. The High Court is requested to firstly take up that matter within 1 week and subject to the objections maintainability, etc. If the High Court finds that the said appeal to issues can be decided together. Maintainability, etc. It will be in the interest of justice that both the appeals are heard and decided together. Heard and decided together. If such a recourse requires the change in composition of bench for deciding criminal LA number 539 of stroke 2020, Honorable Chief Justice of the High Court will do the needful in this regard. Anything else you want?
There are 8 connected appeals which have to be decided with this 539 of 2020. They are all co-accused. So it's not my appeal. There are 8 connected appeals.
Connected appeal of other countries.
With 539 of 2020, the present appeal. So they all have to be decided together.
If there are, next paragraph, if there are other connected appeals, those two also be taken up and decided along with the lead appeal, along with the lead case.
Then if it is not decided in 3 months, my lords, then where do I go?
Yeah,
So then I'll be back for.
Incidentally, I am not retiring in 3 months. My brother or both in any case will retire after me. So there nothing is that unforeseen circumstance we should see.
I have hope, my lords. I'll be back before your lordships. Grateful.
Lord, bail matter. That's the also.
Issue notice.
Accepting.
Advance.
You like to accept? No?
Accepting.
Then so accept notice. Counter affidavit if can be filed within 1 week. Counter affidavit for like 10 days.
2 weeks.
2 weeks. 2 weeks post the matter on so date for further consideration.
Get me there.
Will question is V में आएगा. Extra 23. Any comment? Twenty-three. We just follow 23.
Lordship, it's specifically refer for the prayer.
This writ is not maintainable. Kindly have the prayers, my lord. If he has a grievance, then he can approach the High Court, my lord.
Uniform standard operating procedure governing freezing.
And that is already on.
Accounts linked cyber crime investigation. How can such a direction be issued? sir?
Lordship, the thing is, after the last
It has to
order,
be decided on case to case basis.
Lordship,
Where you find that yes, freezing is absolutely unwarranted, you can go, the court can interfere. And that, why should we entertain this?
Lordship, there is a subsequent development after filing of this order on a 16 January of the last order. Delhi High Court also issued this similar.
That matter is also today.
That's a suo motu petition.
So is it listed today?
Yes.
Okay. We'll hear it up to you.
Yes. Lordship, just consider the order passed by the Delhi High Court in a similar matter where the Home Ministry come with the standard, they've already issued some SOP. So if SOP is there, then just let it be.
High Court of Delhi High Court judgment before us.
My lord, I am also in the matter 47, similar matter, my lord.
And then one more part.
Judicial High Court is UP, Allahabad High Court.
My lord, these accounts are being frozen across the country, my lord, and
Ground to entertain these petitions.
multiple states are doing in the same account, my lord.
Accordingly dismissed, however, with liberty to the aggrieved persons to approach the jurisdictional high courts on case to case basis.
Lordship, before concluding my. I just want to point out one thing.
Everything coming under 32, as if there is no other.
This is being misused by the law enforcement authorities quite a bit.
Absolutely.
Kindly, it is
It is
required,
high
my
time
lord.
that they must do something very.
I am in Mumbai. My account is frozen for 4,000 rupees from Jammu Kashmir, my lord.
Then go to High Court, approach the High Court.
So that's the concern of the entire petition, that if I'm standing in.
There has to be
Uttar Pradesh,
proportionality, my lord.
Complaint filed before.
Every person like this start coming in the 32, what will be the end?
More than multiple
you are
states
not
involved.
yes.
My lord's intervention and the law has to be settled, my lord.
We will, don't worry, we will do that. We are right now.
Kindly issue notice and
Sorry.
allow some relief, my lord.
Question of issuing notice in these matters, where you are suspected to be involved, where is the question of issuing guidance at your instance?
47, this is my customer, it's a consumer matter only, 4,000 rupees.
Yeah, thank you very much, thank you.
Kindly have a look at page 60, just 1 second, my lord.
Not see anything, please go to High Court and show.
It will be,
Go to
no,
High
my
Court
lord,
and-
can give, just see my customer is there.
Yes, yes.
And they are misusing this, after 8 days they are filing this complaint.
Customer, the banks are hands in glove, this is what the report shows. We don't want to say anything because it will cause serious prejudice to all of you. The banks, their officers are hands in glove in the matter of digital arrest and the cyber crime of looting this money. It's not extortion, it's a
My lord, but I am suffering.
brazen loot.
Yes, Lordship.
Bank might be involved, but I am suffering, my lord.
Lordship is absolutely right.
What
There is
can
a
we
bank
do?
are involved, but in this case, those are not directly complained.
Therefore, please go to, that's why you said case to case basis. If you are a victim, you will tell the court. If you are clean hand, you will tell the court that I have nothing to do with, court will pass an order.
We are not concerned with the transition itself.
Thank you very much, thank you.
Lord, there is no FIR, nothing, just the misuse of the I4C mechanism.
Yes.
Kindly issue some guidelines on this for the defreezing, my lord.
We will not issue right now, we will see at the time of final hearing.
And my entire business is gone, my lord, because my account is completely frozen, my lord. I am a small time professional operating out of Mumbai, registered with SEBI,
Yes,
my lord.
item 24. Lunch. Yeah.
May I request that 24 may be stood over?
That would be the no.
Lord, may I request that 24 may be stood over to tomorrow or any other date? There was some misunderstanding. I thought this was the matter where notice had been issued and
Next Monday, Mr. Singh.
there was some miscommunication on my part. Can I request of your lordship?
No, you wanted to place on the additional
We
document.
placed those, but I thought this was the matter where notice was issued. I mixed it up because no reply was there in that matter. So if your lordship could keep it either tomorrow or Friday, or whichever date your lordships.
Friday, we are avoiding Friday.
Or Monday, there was just some miscommunication on my part.
Want on next Monday we can take.
We have already filed the documents. I had some misunderstanding about which matters listed.
We will say like this.
Monday, if your lordship would keep it.
Mr. Sri Singh and Senior Counsel informed that additional documents have been filed. They registered directly to tag the same, post the matter for further consideration on Monday.
Deep blue letter.
ट्रांसफर करना है
May it please, ma'am.
Item 26,
26, your lordships have already.
You have allowed that matter, huh?
Despite your lordship's order, every day they are filing
They are
cases.
still
in
filing.
Kolkata, my lord.
Then if we issue notice and you remind us, then we'll impose some exemplary post.
I'm grateful, my lords.
How much the amount in dispute?
My lords, the loan amount was 1 crore, out of which we went to DRT and we paid substantial amount.
Issue notice to the respondent, returnable on so and so date. The respondent bank will also show cause as to why contempt of court proceeding and exemplary fine cost be not imposed on it for filing complaints at. The complaint has been filed which place?
My lords, Kolkata, my lords.
Huh?
Kolkata.
Has been for filing the complaint at Kolkata instead of Nampally, Hyderabad.
Correct.
Basti.
Till then, the proceedings may be stayed, my lords. Till then, the proceedings may be stayed, my lords.
You serve them next week. What is the next date?
My lords, the next date I have to verify, my lords. I have to verify.
Meanwhile, further proceeding before the Calcutta so and so shall remain stable.
I'll do that, service, my lords.
Bengal SI.
Item 48.
Grateful.
Yes, my lord.
Huh.
My lord, may it please your lordships.
We will take up along with those matters. We will take up along with other matters. Everybody now start filing separate cases. We'll take up along with the other cases. Coming 2 o'clock.
Marat.
Please, your lordships. I have got a brief note of lordships for consideration.
Yes.
Just to give a status report on that, an update. May also hand over the complete status report.
Threshold of 10 crore may be on the higher side, Learned Attorney. Individual losses, I mean, the individual loss of 10 crore.
Yes. But then,
No, but then, you see, there are people, senior citizens, for them, any amount of running into few lakhs, particularly in a case like one of the retiree couple, where which prompted us to take suo moto. There the loss was 1 crore something.
That's right.
But so look at that, for them, the entire life saving.
That's true. Nobody has any, but the government is very keen. We should put all these schemes in action mode as early as possible. But unless we complete this exercise, it will be like working in darkness. So I think it
SOP initiative we appreciate. That's
the SOP in fact is very exhaustive. And there are some Rajasthan High Court and Kerala High Court, some judgments have come. We are trying to look into them. As much as they can add on to the SOP, we'll try to add on to them. But I don't.
You can apprise us if the high courts are also entertaining. We don't want any parallel proceeding to come.
That's true. That's right.
That we can transfer those.
So the SOP as of now, I think, is fairly comprehensive, and let it take shape by giving putting it in action mode. And therefore, your lordship to kindly, in terms of the status report, kindly turn to page number 9 of the status report.
Oh.
As of now, I think in view of the progress being made, this limited direction would suffice. I had a word with the learned amicus, and we value her input being given to the government, and she will continue to be associated with the deliberation. So page 9.
That's it.
This will go a long way in now trying to expedite the entire process of deliberations. There's also, I think, I suppose the learned amicus would share her views with me, and we'll try to, I said, add quality by adding our inputs into that.
My lords, I have filed a written submission pursuant to the status report. I've tabulated, there are 2 status reports that were filed, one by MHA and the other by MEITI. The first one being of 13/1/2026 and the second of 29/1/2026. I have tabulated it and I have shown what are still pending and that which has been addressed at least at a preliminary stage. And I'll continue to, I'm hoping that there will be cooperation from all the departments because, my lords, the status as it stands today and from the status report also is that every action that has been mandated or warranted by my lord's directions or as suggestions from all the stakeholders collated and submitted along with my suggestions are work in progress. So they have pointed to some of the actions already taken under various circulars, but there is not yet further action or suggestions on what is to be done next.
I think if the SOP is approved.
Yes, the SOP is a critical.
This note summarizes, I think, the ongoing deliberations and the time frame within which, kindly, if you lot kindly turn to in the 2-page note, there are 2 or 3 things which are essential before you go further. For instance, E. We have A, B, C, D, E. So RDV has drafted the SOP. Then E, Department of Telecommunications drafted the telecommunications user identification rules.
I think all the departments are now in action.
So these are all very important.
Well, all of them have come aboard. RBI has still to have a meeting. They have not yet had deliberations with me.
SOP is by RBI.
They have mentioned it, but I have.
That's
not
right. And now
received
it's been
copies.
finalized now. The SOP has been.
The only SOP I have is from I4C, which was prepared pursuant to the Chhattisgarh High Court's order. But that was also a preliminary stage and it has not yet been submitted before
What we
Lord.
do is that this SOP, because the action is the essence of this entire, this to deal with this crime effectively. So we issued the directions to implement the SOP immediately. Meanwhile, you critically examine that is there any lacuna or vacuum left? And then we will request them to address that.
Attorney
There's no
General
fees.
has, very fairly, I would say,
Taken you into confidence.
reached out and requested me to be
The
part of
SOP
the
is a product
deliberation.
of
very good.
It would be my
Yeah, in fact.
That's very fair.
duty to contribute. I will be most happy. My lords, I would only want to put this first, and it's recorded in the meeting also, which I had attended. This is a consensus mediated process, and all the departments are coming on board keeping that in mind. There have been extensive discussions, they have been cooperating, but the only thing that I have requested, and that's what my note encapsulates, and that is that the action that needs to be taken pursuant to some of the lacunae having been pointed out, that still remains to be done, and some timeline may be fixed by which they will do that action. And that would also help us to then,
Timeline
for the departments to revert.
Reporting compliance, banks.
No, if you like to see this 2-page note, we have broadly hinted at
That will
what
remain
timeline is
pending.
possible.
The matter will remain pending. Today we are at the stage of formulation of policies, rules or regulations. Once that is done, then definitely, and those are made implemented, then we will have the status report with regard to that, what is the actual action taken at the.
Yes.
The government is very keen to expedite it as early as possible, and there's no difficulty at all about it.
Say, on continuation of the previous orders, including the 16th December 2025, London Attorney General for India is going to see R. Venkatramani, London Attorney General for India.
Let me know.
Has placed on record a complete detailed inputs in respect of the submission of DOT, semicolon R3 is a copy of the detailed inputs and supporting material in respect of the submission of RBI. R4 is a copy of the input shared by 8Y in form of status report, and R5 is a copy of the SOP for NCRP CFCR F RMS, custody and the restoration of money and grievance redressal. It is pointed out that after forming an interdepartmental committee, don't say after, it is explained that an interdepartmental committee has been constituted. The Central Bureau of Investigation has entered. Is to be direct the state of Gujarat and NCT of Delhi to accord the necessary permission within 1 week. Within 1 week. Next paragraph. It is pointed out that the banks are using their own AI/ML tools for fraud risk management. About 26 out of 53 banks are stated to have also adopted Mule Hunter AI. Most importantly, Reserve Bank of India and Indian Cyber Crime Coordination Center, Ministry of Home Affairs are in the process of finalizing MOU for sharing suspect registry data to enrich mule account detection tools in bracket preventive and responsive dash data for cyber criminals and mule accounts available. Lincoln helps black fraudulent transactions, and to help in blocking fraudulent transactions. We will appreciate if the draft MOU is finalized. How much, Learned Attorney, how much time it likely to take the MOU, this MOU?
It'll take about 3 or 4 weeks. 4 weeks time at least.
Is finalized within a 4 weeks or so.
4 weeks time.
Next one. You have Parabai Likhiran. Similarly, RBI has drafted a standard operating procedure prescribing actions by banks for placing temporary debit holds on amounts, to prevent money mule activities and cyber-enabled fraud.
Next page. There are two SOPs if you lot will make sure. Yeah. One you should notice in page 1 and page 2. IJ, serial number J.
This is to be.
And that's what is referred to in page number 9.
So this D is to be implemented.
No, sir.
J has to be implemented.
The mule account money is kept.
The reference in page 9 is to serial number J.
There is no serial number J in this. Which one? Which one? This? There is no serial number J in this. This no?
CRP-CFRMS, custody and restoration of money and grievance redressal has also been approved on 2nd January 2026.
Yes, and at page 9 of the IA,
We
request
direct
the court to implement that.
consequently, we direct that both the SOPs.
It's essentially MHA's SOP.
MHA. MHA is only one.
On J, sir.
MHA is only this one.
No, MHA.
This will comprehensively address because some high courts have issued some direction. Rajasthan High Court. But this takes care of all that. What I suggested to the
SOP at serial number, MHA's SOP is only serial number J.
that's right.
So we accordingly direct the Ministry of Home Affairs to formally adopt and implement the above stated SOP dated 2nd January 2026. And the same be issued across the country for adopting a uniform process to strengthen inter-agency coordination to ensure the timely restoration of defrauded funds wherever possible and enhance
By all the parties.
direction to the High Court or High Courts? Assuming I had to cut in the next paragraph, the High Courts, all the High Courts will ensure
That the adjudicating authority.
adjudicating authorities within their respective jurisdictions
Ensure compliance of this.
comply with the above mentioned SOP.
Ensure compliance, because High Court to ensure compliance.
Ensure compliance of the SOP. Then say, it is also pointed out by one Attorney General that
As far as those items in page 2, those future action, that will form part of ongoing deliberations.
that the Department of Telecommunication has drafted the telecommunications in bracket user identification bracket close rules 2025 as well as the draft telecommunications in bracket radio equipment possession authorization bracket rules the comments from stakeholders stroke general public have been invited. These rules are being formulated to prevent one eye biometric E-KYC and the issuance of number of SIM cards in one box. Besides, to route international calls as local ones via voice over internet protocol, etc. So these rules can be notified immediately.
They are asking for 2 weeks.
Oh,
2 weeks.
let these rules be notified within 2 weeks.
I think a little more time is to finalize.
Don't ask for
rules.
2 weeks.
I know. I told the committee.
All right,
I would like to probably look.
Only 3 weeks. 3 weeks. DOT has also implemented centralized international out roamer in bracket CIOR in October 2024 for addressing the issue of spoof international calls to prevent, which helps identifying calls made by genuine international roaming subscribers.
The spoofed international, which helps identifying.
I know.
Helps identify call for genuine. Probably both.
Compliment होता है.
उसमें आता है ना कि spam.
Spam.
उसका है. The Ministry of Electronic and Information Technology.
Only one copy given to CPRC. I see. I think there was a small, the copy which I hand over, it was probably meant for my reading. It's gone to your lordship's hand. I think it makes a lot of sense that way.
But it is helpful.
All in the brackets are all meant to instruct me.
Oh, okay. We don't mention this preventive or anything. We will simply set the rules only. But it helps in issuing the time direction. The
होटल सेटअप करने के लिए
जी के बाद
change.
जी is already नहीं 424 में हो चुका है.
हाँ नहीं
Can I hand over another copy?
I would like to get the one with the notes in.
Next paragraph. Ministry of Electronics and Information Technology is directed to develop and finalize a portal for reporting the complaints under section 43 of the Information Technology Act 2000 That will be done within how much time?
It will also require some time. That will require some time, just, it will also require 4 weeks. Let it be around the same time, 4 weeks. And if you're able to expedite it, I'll come back and report.
Let the needful be done within 4 weeks.
Yes, yes.
Let the needful be done within 4 weeks.
उसके बाद ठीक है, सब ठीक।
Rest is, rest is fine. But the so far as the future course of action is concerned, it is pointed out that from how we direct the CBI to expedite a registration of the identified digital arrest cases for investigation. RBI is directed to examine the recommendations of the delayed transactions at the end of the issuer bank and take an appropriate policy decision in this regard. The Ministry of Electronics and Information Technology is directed to follow up with intermediaries for time-bound compliance, for which necessary meetings with the concerned agencies may be held. We don't mention any particular thing. Appears. May also jointly hold a meeting to evolve some framework for victim compensation in digital arrest cases. It will be appreciated if a pragmatic approach is adopted and a pragmatic and liberal approach is adopted in this regard. Let a fresh status report, next paragraph, let a fresh status report
as well as POS, so that the issuance of SIM cards cannot be subjected to fraudulent or additional issuance beyond the caps that DOT itself had mandated. That aspect is not covered in the note at all.
I think
Further,
there are two sets of rules. One rule is meant for this one.
no, not for the dashboard minutes. The two sets of rules will be external facing. This has to be internal facing, because this will have to be a functionality that DOT, TSPs and POS will have to do together, which has nothing to do with the user framework. The two rules are pertaining to user framework.
Tell them to examine this aspect.
My lords, the second thing.
The status report refers to it at page 3 at bottom. We'll examine that.
My lords, the next thing is DOT has the mechanism to impose penalties. That we have raised the suggestion that should also then include compensation. Penalties has to be commensurate with the loss caused due to the negligence or willful misconduct of a TSP or a POS, and that has to accrue to the benefit of victims. That again is not addressed. The similar thing with respect to RBI, this Honorable Court has noted repeatedly the way the systemic rot or misapplication has happened. But RBI, whilst imposing penalties, imposes nominal penalties against banks which are violating its own circulars, which is not commensurate with the loss that accrues because of the violation. For instance, my lords, I have recorded that Mule Hunter as AI tool has been implemented by 86 banks. Mule Hunter is developed by RBI. RBI's own circular mandates that banks have to evolve AI tools, which goes beyond Mule Hunters. Yes.
Kindly turn to page 13 of the report.
The mandate was not just to implement RBI's Mule Hunter, but to develop AI tools which will include velocity checks. And that is what I had submitted earlier also, my lords, that where a digital arrest victim transfers funds which are unnaturally high, even that can be detected using AI tools and can be paused or it can be a trigger which will then ensure either pausing of the transactions at the issuer bank itself or at the receiving bank's end. That itself becomes a trigger. That has not been addressed.
Give a note to the Electronic Trust.
Well, this has
Kindly
been
turn to
raised
page,
at
10.
the committee meetings, and they will have to revert on that. But since my lords are saying that the status report will have to include this may also be added, my lords.
Just give a note that during.
Lords, kindly turn to page 10 of this status report, Annexure R1, action taken by RBI. At the bottom of that page, the following discussions were held and so, and cyber-enabled frauds. RBI informed that of 26 out of 53 major banks have adopted the Mule Hunter AI.
That is my submission. We are not just talking about detecting mule accounts.
1 minute.
It goes
And
beyond that.
And clarify that Mule Hunter AI is supplementary and not mandatory. The Honorable Supreme Court directed use of AI/ML tool generally and not any specific solution. Many banks have their own AI/ML tools for fraud risk management. The detection efficacy of Mule Hunter AI varies across banks from approximately 25% to 90%, and concerns are noted regarding high exposure bank. It was noted that RBI and 14C I4C MHA are examining a draft MOU for sharing suspect registered data to enrich Mule account detection tools. So I think it will go forward.
My lords, this is my submission, that all of this pertains to mule accounts, not to velocity checks.
One thing is there are in situ circulars with regard to reporting compliances.
Yes.
No.
That if RBI can strengthen the compliance of the reporting duties of the bank.
Certainly. Therefore, the
with regard to suspicious transactions and suspicious accounts.
And my lords, if the
Perhaps help
RBI
at an
ombudsman,
early detection and thereby some remedial.
my lords, in every case of digital arrest, the submissions that have come point out that the RBI ombudsman has not really taken into account the kind of situation in which the scam has happened. They merely say you have voluntarily transferred, and that was the first submission that RBI made at the committee also. So the fact that the victim transfers voluntarily is part of the scam, but that cannot be held against them for compensation or for remedial action.
I would suggest all these concerns.
The requirement of banks to develop AI tools and implement them goes beyond finding mule accounts. That is my submission, my lords. And that is RBI's own circular, which forms part of my first submission.
That matter may be better left up to the central bank.
My lords,
Maybe
and therefore,
best left to the central bank.
my lords, my submission is that RBI should
Better tools.
implement
They
it,
are showing.
enforce penalties if there is a violation. Merely having a circular will not ensure implementation unless there is a penalty that.
We are in the process of consolidating. So do you have a complete clarity on how it really works? So of course, certainly RBI is going to look into it. And
See, there will be certain gray areas where probably with a view to whatever maybe, we will not say that it is their compulsion, but they will not like to pressurize the banks to adopt certain things. They may not like to pressurize. But that does not mean that we will also finally agree to that. We will see that what is to be left for to be done by us.
My earnest request.
if only RBI detects that there is a complete, yes.
If RBI does not take any stern policy decision, even at this stage.
Yes.
When the the information in public domain, official or unofficial, suggests that definitely more than 25,000 crores rupees.
Yes,
of
I
this
know.
country has been siphoned. So one of the figures sent to me, it talks of 54,000 crores plus. 54,000 plus crore of hard-earned money of these victims has been siphoned, taken away. That's why I was telling before lunch in some other matter that it is not extortion.
I heard that.
Brazen loot.
I heard that, yes.
And this is absolutely robbery and dacoity. Now, if the banks, if it happens either because of the collusion of the bank officials or if it happens because of their negligence or their perceived action of not annoying the customer. So that means that a kind of a tacit appeasement of the customer. It is not. The banks also need to realize that a customer, if suppose there is an account of a corporate entity, every day the transaction of lakhs of crores is taking place. There is nothing like doubtful in that transaction. But a retiree who is only withdrawing rupees 10,000, 15,000 per month, and suddenly from his account 50 lakh, 70 lakh, 1 crore is being released. Why your AI operated, there's some app in the bank will not peep alarmingly that this
That's why
transaction need
this
to be
note says-
rechecked.
I understand that. That's why this note says on average, but about 75% is successful. So where it has not been able to work for a variety of these reasons, I think RBI will address that question.
Because we hope that they don't invite a direction, and if the RBI can introduce some.
No, morning I had
It
discussions
has
with
to be a very
IPOs.
robust mechanism. This definition of suspicious transaction is the central point for consideration by the banks, whether they are private financial institutions or public sector.
Have the circulars as to what is the suspicion.
Yes.
It's a huge network that has developed over a period of time.
Mr. Attorney,
So on the
this-
mule account that
this
are
problem is the banks are more into a business mode, and naturally so, with ideas of profit earning. And in doing that, what they are becoming, either innocently or maybe connivingly, the platforms through which there is a very swift and seamless transmission of the stolen proceeds of crime. You see, your report says 52,969 crore. They do not show compliance leverage.
some PSU banks score high